and please keep the session. If you have any question, please use the chat box or raise your hand. Now, I would like to invite Ms. Hiranshi Shah ma'am, founder of Sambhav Initiative, for welcome speech and to brief about the capacity building program. Before that, I would like to take a moment to introduce her. Ms. Hiranshi Shah ma'am is an exceptional individual with a distinguished career in alternative dispute resolution. She is a member of prestigious organizations such as Chartered Institution of Arbitration in United Kingdom and the World Mediation Organization in Germany. She is a member of esteemed like the Singapore International Arbitration Center, the London Court of International Arbitration, and International Council for Commercial Arbitration. Over to you, ma'am.
Thank you, Saurabh. First of all, I would like to welcome all, and firstly, my own patron of Sambhav Initiative, Justice Emma Shah sir, under whose vision and guidance we are able to organize all these various kind of capacity building program. And also, I would like to first welcome our today's keynote speaker, PK Malhotra. Sir is also joined. Thank you, sir, and welcome. I also welcome all participants whosoever join us today. So this 10 days online national capacity building program on legislative drafting, public policy making and legislative analysis, we are organized with the aim to enhance the audience and participants about the drafting of the legislative, wherein we are invited various keynote speaker from the Ministry of Law and Justice, Government of India, Parliament of India, and also the Law Commission of India, wherein they were going to share about the overview of legislative drafting, interpretation of statutes, also the how to draft the public policy, how to draft the bill, and also the journey as from the bill to act upcoming 10 days. So hope in upcoming 10 days all we are going to be learn during this sessions. So thank you everyone, and once again thank you to join us today.
Thank you so much, ma'am. Today our inauguration ceremony is graced by our Chief Guest, Justice M.R. Shah sir, patron of Sambhav Initiative. Honorable Justice M.R. Shah sir is a former judge of Supreme Court of India. He was enrolled as an advocate on July 19 in 1982 and practiced in Gujarat High Court and Central Administrative Tribunal in civil, criminal, constitutional, taxation, labor, service, and company matters, and constitutional, education, excise, custom matters also. He was appointed as an additional judge of the Gujarat High Court on 7th of March 2004 and appointed as permanent judge on 22 June 2005. He was appointed as the Chief Justice of Patna High Court on 12th August 2018. He was appointed as a judge of Supreme Court on November 2, 2018. Sir retired on 15th of May 2023. He has written more than 700 judgments in 4 years and has been part of several high-profile cases. We are very honored to have you with us today, sir. Over to you.
Good evening to all of you. Another initiative by the Sambhav Initiatives. Congratulations to Hiranshi and her team for organizing this 10 days online national capacity building program on legislative drafting, public policy making, and legislative analysis, jointly organized by Sambhav Initiative and Pro Bono India. I welcome all of you, and I'm very happy to associate today with all of you on this inauguration ceremony of 10 days online national capacity program. It is my own institution. Therefore, I'm very happy that one after another programs are being organized by Hiranshi and her team on so far as the subject is concerned, subject chosen is concerned, a very important subject so far as the legislative drafting is concerned. if you see the legislative drafting is perfect, then you can avoid so many litigations. Many a times the litigation starts on interpretation of what is stated in the legislation. To avoid that, we will be the better legislation is required so that there is no confusion in future or misinterpretation, or there is doubt in the interpretation on any legislative legislation. So in the governance and the public at large, even also the legislative drafting, a perfect drafting plays a very important role. So I'm very happy to note that Sambhav University has again come out with a good program and on good subject. Today we will be having a very renowned person in the administration, Shri P.K. Malhotra ji. I welcome Shri P.K. Malhotra, former Secretary, Ministry of Law and Justice, Government of India. No other person better than Shri Malhotra would be there to guide us on the legislative drafting and on policy making. I welcome him. In this 10 days program, we will be having a different speakers right from the Law Commission, the Ministry of Law and Justice, and Gujarat Sahitya Academy, Political Science Maharaja Professor, and all other dignitaries who will guide us on the proper legislative drafting. With this, I congratulate all. I welcome all the participants who will be who are participating and who will be participating in these 10 days. Once again, I congratulate Hiranshi and her entire team. Thank you very much. Jai Hind, Bharat Mata ki Jai.
Thank you so much, sir. Malhotra sir, with your kind permission, may I start the session?
No. Hiranshi, may I leave now?
Sure, sir.
Malhotra ji, welcome. This is Justice M.R. sir.
Thank you very much, sir. Thanks for the kind words used by you. It's a pleasure to be.
You deserve it. No other better person than can be there.
Thank
and
you.
I am happy that you have associated yourself by this initiation, and in future also you will guide us whenever required, sir.
Lordship, Hiranshi has been contacting me earlier also, and I think I had an opportunity to interact with the participants on your platform. And
Correct.
I must compliment the team of Sambhav Initiative as well as Pro Bono India for choosing such an important subject, about which I think even the people who are drafting the laws in the Ministry of Law and Justice and in the legislative department of the state governments probably need to be told many things which we have been facing on day-to-day basis, and the kind of innovation which is taking place. Probably all those experiences need to be shared with all those people. And I think there cannot be a better platform than this under your leadership. And I think the participants will definitely be benefited with your leadership, as well as the other speakers who will be coming here. They are almost all of them are my colleague who have either worked with me in the law ministry in the past or are right now also working with me. So we will be sharing our experience, Lordship.
No, thank you very much. Thanks a lot, dear. Thank you.
Thank you, sir.
You can start now.
So Hiranshi, are we going to start it, or shall we wait? Because I think.
Yes, Saurabh, over to you.
Okay. Good evening, everyone. Saurabh this side, moderator of today's session and delegate of Sambhav Initiative. As today we mark the beginning of our program, we are excited to commence with our program session focused on overview of legislative drafting. Before starting the session, I would like to mention that the last few minutes of the session will be reserved for question and answers. Today, we are very honored and privileged to have Mr. P.K. Malhotra, sir, former Secretary, Ministry of Law and Justice, Government of India. Mr. P.K. Malhotra, sir, has more than 40 years of experience in the field of law in various capacities, out of which he has worked in the Ministry of Law and Justice for more than 25 years as an officer of Indian Legal Service and reached the apex level of Union Law Secretary. He was responsible for processing and finalizing many important legislation, including Criminal Law Amendment 2013, Constitution amendments relating to National Judicial Appointment Commission, Companies Act 2020, Representation of People's Amendment Act, Bill, Commercial Codes Act 2015, Arbitration and Bankruptcy Code 2016, and many other important legislations. Malhotra sir has held several key positions such as Secretary, Ministry of Law and Justice from December 2012 to April 2016, Member of Law and Commission of India from December 2012 to April 2016, Presiding Officer and Member of Securities Appellate Tribunal, Mumbai, Chairman, Adjudicating Authority, Prevention of Money Laundering, Additional Charge from February 2008 to April 2009, Arbitrator and Appellate Authority under Permanent Machinery of Arbitration of Government of India, PMA, in more than 100 arbitration matters. I can go all day speaking about sir's accomplishment and pivotal role in Indian legislation. So you are a true inspiration for advocates and students like me. Thank you so much. And we are very honored to have you with us today. Over to you.
Thank you very much, Saurabh. First of all, I think we were supposed to start the technical session from 7 o'clock, but since I joined the inaugural session also, and we are starting the session early, how much time I have for my talk?
Sir, around 1 hour.
Okay, fine. Thank you very much. So first of all, I must thank Sambhav Initiative as well as Pro Bono India for inviting me to the first lecture of this 10 days National Capacity Building Program on legislative drafting, public policy making, and legislative analysis. Mr. Jayant Agarwal, who is the event coordinator, and Hiranshi Shah both have been in touch with me for quite some time. And of course, I was supposed to travel out, but this was such an important program from my point of view, because I thought that I must share my thoughts and experience with the people who are in the field, who are students, who will be the legislature or the draftsmen or advocates of the future. I must share my experience with them on this occasion. And more particularly, when I knew that this is an organization which is being patronized by none other than Justice M.R. Shah, that gave me an additional incentive to come and participate in this program. Now, the topic which has been given to me today is the overview of the legislative drafting, and I think that was the best subject with which this 10-day national capacity building program can be started from both the students as well as the young practitioner, because most of the time they may not get an opportunity for drafting, but as rightly pointed out by Justice M.R. Shah, that drafts, the legal draft or the law is the most important subject, because every litigation starts with regard to the interpretation of law only. If the laws are well drafted, probably the litigation can be reduced. If the laws are not well drafted, probably that leads to a lot of litigation, burdening the courts with many litigations, which can be avoided in case the legislation is properly drafted. Now, when I'm talking of legislation, I'm not talking of the principal legislation, which is drafted by the parliament or the state legislature, but I'm also talking about the subordinate legislation, which are rules or regulations framed by the government, state government or the central government in their executive capacity in exercising the power given under the act, as also the statutory bodies which make regulations to regulate their own procedure in carrying out the duties which are given to them under the act. And on the lighter side of it, it is generally said, and I share with you, if a legislation is well drafted, normally credit goes to the parliament, that, oh, such a wonderful law has been drafted by the parliament. But if it is defective, normally it is said, oh, what kind of fault the draftsman has done? He doesn't know how to draft a law. So the credit is taken by the parliament, and generally this credit goes to the draftsman. So I think the draftsman duty becomes very, very onerous. And I'm quoting from an article which was written by Justice Brajesh Kumar long back. And when he was Allahabad High Court judge, later on he came to the Supreme Court. And what he said in the beginning of his article, and I quote, legislative drafting in itself is a subject for serious study, but unfortunately, it appears that in India, required attention commensurating to the importance of the subject has not been given to it. By and large, drafting of statute is generally in the hands of those who do not have specialized training and experience in drafting, so to say, in the hands of the law-knowing layman in drafting. They may be the lawman, they may be knowing the law, but so far as the drafting is concerned, probably they are the layman. In England, the job of drafting is done professionally by those who have adequate training and expertise. But in America, like in India, the position seems to be no better as compared to India. This is the opening sentence of the article on legislative drafting, written by none other than a former Supreme Court judge. Before I come to the issues relating to the drafting of laws, as to how it is drafted, what precautions should be taken, I think it's better for all of us because we are student of law, we are practitioner of law. Where is the legislative power? I think let us first have a look at that. The power to legislate or to pass a law is with reference to the topic entrusted to it is unqualified, subject only to limitation imposed by the Constitution. Meaning thereby, the legislature have unlimited power to make law on any subject, subject only to the limitations imposed by the Constitution. And all of us, being student of law, being practitioner of law, we understand that this Constitution has been given to us by we the people of India. And we the people of India, when we drafted this Constitution, we created three organs of the government. Which are those three organs? The legislature, executive, and the judiciary. Legislature makes the law, executive executes the law, and judiciary interprets the law. And in case the executive or the legislature has exceeded its power, the power of judicial review under the Constitution is given to the judiciary. Therefore, the parliament does not interfere with the day-to-day administration of the executive, but exercises surveillance on it when the rules are made. Because, you know, as I talked about the subordinate legislation, rules are made, rules are subject to scrutiny by the parliamentary committees. And again, as I said earlier, the parliament has the sovereign power to make the law under the constitutional scheme. The parliament exercises sovereign power to enact laws, and no outside power or authority can issue direction to enact a particular piece of legislation. This even has been confirmed has been said by the Supreme Court in Union of India versus Prakash P. Hinduja, which is a judgment delivered in 2003 by the Supreme Court. And the Supreme Court says, under the constitutional scheme, the parliament exercises sovereign power to enact laws, and no outside power or authority can issue a direction to enact a particular piece of law or not to enact a particular piece of law. Then the question arises, how this, because we are a federal structure, we have the central government, we have the state government. There is a division of power, legislative power also between the center and the state. How this legislative power is distributed among the legislature, that is the state legislature and the central legislation. And just to refresh your memory, it is provided in Article 245 to 255, read with Schedule 7 of the Constitution. As you know, there are three lists. There is a list one, union list, which is about which the provision are made in Article 246 of the Constitution. We have list 2, which is a state list under which the state legislature can make the laws, which is under Article 246, Clause 3 of the Constitution. And then we have the concurrent list, which is again in Article 246, Clause 2, which on which the state as well as the union government can make the laws. So far as list 1 and 2 is concerned, generally there are not many questions. But with regard to list 3, because there is a concurrent power of the central government as well as the state government to make laws, therefore, generally question arises with regard to the jurisdiction on this particular aspect also. But that can be a topic of separate discussion, because today we will be concentrating on the drafting of laws. But this is just to refresh your memory where the power is. But at the same time, let me caution you that the entries in the legislative list are not the source of legislative power. They are only the list which have been given, that these are the power these are the list on which these laws can be made by the parliament, by the state legislature, or by both of them under the content list. These lists, therefore, the items mentioned in these, therefore, must receive a liberal construction inspired by a broad and generous spirit. The doctrine of pith and substance can be applied, and if the legislation has a substantial connection with the entry, the matter may be taken to be legislation on that topic. Now, just to give an example to explain it, I hope all of you know about the goods and services tax. The service tax was initially not there under the Constitution. It was introduced way back in 1992. The question was, service tax is not specifically included in any of the list. Therefore, the parliament doesn't have a power to levy service tax. But of course, later on, the amendments were made. All of us know in 2015, the Constitution was amended, separate law was also passed. But the Supreme Court interpreted it, saying that the residuary power given to the parliament in list 1, this tax can be covered under that. So I think liberal interpretation was given, and this is what the Supreme Court, in the case of Ujagar Paints versus Union of India in the year 1989, has said that this is not the source. The power lies in the Constitution itself. The list is only illustrative, and the items given in the list are to be given widest interpretation to empower the government to make law on any of the subject. And in case any item is not not mentioned anywhere, then the residuary power lies with the parliament under list 1 of the Constitution. Another important aspect with regard to the Constitution is, many times somebody can say that why parliament want to make a law on this particular subject. Again, the Supreme Court has said, if the legislature is competent to make a particular law, its motive in enacting it, or the fact that the law would operate harshly on some person, or that it failed to enact a connected legislation, is irrelevant. Again, I'm quoting this from the Supreme Court judgment in the case of Ashok versus Union of India, reported in 1997 AIR Supreme Court 1792, where the Supreme Court has said, if the legislature is competent to make a particular law, its motive in enacting it, or the fact that the law would operate harshly on some person, or that it failed to enact a connected legislation, is irrelevant. The point which I'm trying to emphasize is that power to make legislation on any subject to the limitation imposed by the Constitution is endless. It is available to the state legislature as well as to the parliament. Now, this is the general scheme of legislation. You know, this power is there with the legislature, but how the drafting of law is done. Normally, you know, all of us know that each state has got its own law department, which scrutinizes the proposals, and they scrutinize the proposal from definite angles, specified angles. And those angles are, number one, whether the state legislature or the parliament has the legislative competence to make a law on that subject. And for that, they make a reference to list 1, list 2, and list 3. If the subject is in list 2, state government is competent to make a law, center can't make a law on that. If the subject is in concurrent list, both center and the state can make a law. But a general observation is that if the central legislation is there, central legislation prevail over the state legislation, and to the extent the center has made a law to it. But if the state want its own law on a concurrent list, other than the law passed by the central government or the parliament, then the state assembly has to pass a law on that subject, get the governor's assent and refer it to the president for his assent. And in case the president give his assent to a subject on the concurrence list, which is different from the central legislation, to that extent, that law will stand modified in its applicability to that particular state. This is I'm just trying to explain with regard to the concurrent list. The second point, which is important from our point of view, is that whatever legislation is made, the law department is supposed to see that it is in conformity with the constitutional scheme. When I am talking of the constitutional scheme, we are a welfare state. All of us know we are a welfare state. And we have to ensure that the states are making law which are not violative of any of the fundamental rights. And secondly, they are in conformity with the principles enshrined in Part 4 of the Constitution, that is the directive principles of state policy. All of us understand fundamental rights are political rights which can be violated or which can be regulated only in accordance with the law made in accordance with the chapter relating to fundamental rights. And the directive principle of state policy contain social and economic rights of the individual, the citizens, as well as the people staying in this country. And objective of the law should be to promote the social and economic principle. And before coming to that, the most important part is the preamble of the Constitution, because preamble of the Constitution, which encompasses within it the whole scheme, or rather I would say that this is the gist of the whole Constitution, because it creates for us the fundamentals of the social and economic rights of the individual, and to implement it, the laws are to be made. And if any of the law which is passed by the state legislature or by the parliament which violate any of the principles which are enshrined in the preamble will be struck down by the court. The third important aspect, which has to be seen by the legal person who is advising the government on making a law, is that it is not in conflict with any of the existing legislation. So this is once this legal scrutiny is done, then then the draft goes to the legislative department, and this department gives legal shape to the proposal of the administrative ministry by preparing a draft legislation, and the draft legislation is prepared in consultation with the administrative ministry, which is responsible for administering that particular enactment. For the benefit of the participants here, let me tell you that there are allocation of business rules and transaction of business rules in the central government. Under the allocation of business rule, each ministry and department of the government of India is allocated certain subjects, and that ministry becomes the central government for administering that enactment. Take, for example, we are talking about GST. GST is a subject which is assigned to the finance ministry. Finance ministry becomes the central government for the purpose of that enactment. And in case any proposal or any amendment is to be brought in the GST law, the proposal will be processed by the Ministry of Finance. And as a matter of policy, they will give a broad policy to the draftsman that this is the broad policy which we want to cover under the law. Instead of going into the processing of proposal, now I will be more interested in sharing with you the importance of the clarity and precision in the legislative drafting which is required, because as Justice Shah himself has mentioned, that in most of the cases, litigation is because when we draft the law, there are problems in the drafting of law and there is no clarity, and sometimes the drafting the laws are so complicated that their interpretation becomes a problem, and it gives rise to more and more litigation. The art of legislative drafting is entirely different as compared to drafting, say, convincing the document or the pleadings which are to be filed in the court. There probably you can take liberty with the language, but when you draft a law, you cannot take liberty with the language of the statute which you are drafting. It has to be perfect. It has to be very precise. The fundamental source of making law is the legislature. Other institutions, whether it is lawmaking by the executive or the judiciary, have to build upon the essentials laid down by the legislature. The subject of legislative drafting is thus of extreme importance from the legal process. Legislative drafting is a difficult art. It is the art of expressing in concise and clear language the idea of other people. As I said, while drafting a will, you can take little bit of liberty. While drafting an executive order, you can take little bit of liberty. But while drafting a law, you have to be very, very precise, conveying the meaning which actually the legislature want to convey. In legal theory, a statute always expresses its intention of the legislature. I'll just on the lighter side of it, let me share an experience with you. Recently, it happened. A law was being discussed in the parliament. A bill was being discussed in the parliament, and the honorable minister was explaining what law, why this law has been brought, why they are passing it, and what is the objective they want to achieve. When certain member of the house asked certain questions, he gave a clarification on the floor of the house with regard to the interpretation of that particular provision. I don't want to go into the detail of it because that may not be relevant here, but I'll come to it at a later stage with reference to some other legislation which has become a subject matter of debate right now. And even today also there is some coverage in the newspapers on that. So the minister on the floor of the house said, I assure this house that this law, we will ensure that this law is not misused. The question is whether the assurance given by the minister on the floor of the house with regard to interpretation of a law will become binding on the courts. My respectful submission is not, because whatever is the language of the law used in the statute as interpreted by the lawyers before the court and as finally interpreted by the court in the judgment will prevail on whatever has been orally said elsewhere. So therefore, importance is that the language of the statute must be very clear. Now, you know, we are a common law country. We follow the common law system, and common law system, traditional drafting, normally, I mean, if I'm talking of the traditional drafting, it was, let me, I mean, admit it, that many a time it has been unnecessarily complex and too formal in style. There is a need for simplification, and probably we are moving in that direction right now. We have seen some of the legislation which have been passed in the recent past. There have been pre-legislative consultation process. In addition to pre-legislative consultation process, some outside agencies have also been consulted, and therefore efforts have been made to use simple language, but it is easier said than done, and I'll come to it little later. This has the complicated language when it is used. This has deep influence on the judiciary, and the bar as drafting was done with extreme caution, leaving no room for misunderstanding or ambiguity of any kind of distortion in the basic meaning. This style of drafting uses long sentences, archaic legal expressions, Latinism, and pompous language. This style had one clear virtue, which is to be very precise, giving effect to the intention of the policy maker. I'm talking of the two things. Once you are using a complex language, idea is that it is very precise and effective. But at the same time, it leads to many problems also. Now, I'll give you just 2 or 3 examples for your benefit. One example which I can give is under the Income Tax Act of 1961, there is a section known as section 80HHC. This, as you know, this law has been amended many times. In every finance bill, hundred of amendments are carried out in the Income Tax Act. And this act, original shape, it has lost. And it has become a very bulky document. This 80HHC deals with deduction in respect of profits retained for export business. Now, this section runs into 6 printed pages of the legislation. 6 printed pages and one sentence is running into full paragraph of 10 lines. Think of the common man who has to read this law. He is not able to understand. Without the help of the taxation experts, he cannot understand such a law. This law has 10 subsections. One section, 80HHC, is having 10 sections. It has got 7 provisos. It has got 5 explanations and 16 definitions. Do we need this kind of complicated laws which are beyond the understanding of a common man? I think that is the area where I think draftsman has a very important role, that without compromising with the intention of the legislature, he puts the intention of the legislature, objective of the law in simple sentence to the extent possible. But as I said, it is not that easy as I'm saying. Take, for example, another law which was recently passed, Bharatiya Nyaya Sanhita. This is with regard to, you know, that section 154, which was dealing with the earlier section 154, and now replacement is 113, which deal with terrorist activities. Again, I think this section has been widened. By widening this section, we have now 7 subsections. There are 10 subclauses. There are 3 explanations and 2 definitions to it. And we are saying that we are making the law simple. My anxiety is, if you are simplifying the law, look at the earlier provision section 153 and look at this, which is a simpler law. And of course, we wanted to change that law because that law has outlived its utility. We wanted to bring a new law. But while enacting the law, probably instead of simplifying the thing, we have complicated it. And my anxiety is probably this kind of legislation, which complicates the law and it makes it difficult for the common man to understand, need to be simplified. Now, this kind of drafting has been criticized by the courts also. And they say harsh words have fallen from the judges about the defective drafting. Justice M.R. Shah also mentioned about it. It has been said that the draftsman is generally responsible for half the litigation. I said it earlier in the lighter side. Numerous instances will also be found in textbooks dealing with the interpretation of statutes where laxity of expression has increased the difficulties of interpretation. I give you few illustrations where judges have said something about the legislation and they are looking for simplification of legislation, where Justice Krishna Iyer of the Supreme Court, while commenting on Section 18 of the Immoral Traffic Act 1956 in the case of C.J. Vaswani versus State of West Bengal, he observed, had the drafting been more careful and lucid, the argument would have been obviated. This court has more than once pointed out that lack of legislative simplicity has led to interpretive complexity. The home truth that legislation is for the people and must therefore be plain enough has hardly been realized by our lawmakers. Judges looking at statutes are forced to play a linguistic game guessing at the general legislative purpose and straining of semantics. There are many canons of statutory construction, but the golden rule is that there are no golden rules, if we may borrow a Shavian epigram. In another case of Muralidhar versus State of Maharashtra, way back in 1976, a case which has arisen under the Prevention of Food Adulteration Act, the Supreme Court observed, we cannot but deplore the clumsy draftsmanship displayed in his statute, which affects the common man in his daily bread. It is unfortunate that easy comprehensibility and simplicity for the laity are discarded sometimes through over sophisticated scholarship in the art of drawing up legislative bills. It cannot be overstressed that a new orientation for drafting methodology, adopting directness of language, and avoiding involved reference and obscurity is overdue. Now, this criticism coming from the Supreme Court, why I have highlighted it, that probably there is scope in spite of the fact that for the last about 15 years, we have been making attempt in this regard, but the ultimate objective we have not been able to achieve. Now there has been, already an attempt has been made to simplify the Income Tax Act, which we have said. The bill is already under discussion. New income tax bill is already under discussion. The 3 criminal laws have been simplified and efforts have been made to take out all those things which have become obsolete, and some simple terms have been made use of in the new legislation. But what we have to see is that there is still scope for improvement in this area, and effective language for precision and clarity is still needed. Therefore, the call for a simple yet effective language in drafting is not of recent origin. Unnecessary jargon in law leads to mass dissatisfaction among the public at large, creating sense of inaccessibility. The statutes of the past centuries used to be either in French or Latin, accessible only to few learned persons and restricting the public. However, in recent time, we are witnessing the era of plain language drafting, and I already mentioned about it, where the demand for less use of legalese is emphasized upon. Now the focus on plain language writing is the reader. Public law, nevertheless, has the potential to affect the rights of every citizen. It is for this reason that the case for average person with no specialist knowledge being able to understand legislation is now compelling. Now, I would like to quote here again Lord Denning, who has again emphasized on simplification of laws and use of simple language in the law, when he says, if you are seeking to see what different principles should be applied, the first would be to recommend simpler language and shorter sentences. Very simply said by Lord Denning, simple language and shorter sentences. The sentences which goes into 10 lines is unnecessary. It could be split up into shorter ones anyway and couched in simpler language. Simplicity and clarity of language are essential. We have been emphasizing, but unfortunately, we have not been able to do it. And there are reasons for it. Is it easier said than done? Using simple language, I'm saying use simple language. But mind it, and I'm cautioning that oversimplification of things may not do, and legal draftsmen may also have some difficulties. And again, I'm quoting another judge, Roxburgh, on simplification when he says, language draws a series of mental pictures in the mind of the person hearing the words spoken. These pictures are somewhere fairly well defined and sometimes blurred in outline, but they are never very precise. Language is a medium which disdain mathematical rule, because here in the laws, when you are using language, you have to see it is with an social objective, economic objective, which are enshrined in the preamble of the Constitution and in the directive principle. They are to be achieved, and you cannot have mathematical precision in that language. Therefore, oversimplification is not required. So, what exactly we are looking for in a legislation, what the draftsman should do. Lack of legislative simplicity has led to interpretative complexities. Now, again, I'm saying simplification is needed, but that simplification should not lead to legislative complexity. And again, the Supreme Court, in the case of Vaswani versus State of West Bengal, has observed a statute as enacted cannot be explained by the individual opinion of the legislators. And I quoted that example recently when in a parliamentary debate where the minister explained on the floor of the House, this is not, it is not likely to be misused. We are going to create sufficient safeguard. But if the language is such that it is likely to be misused, it is the court which will look into it, and it is the final interpretation given by the court will be accepted. Therefore, this observation become relevant where the Supreme Court way back in 1957 has observed the statute as enacted cannot be explained by the individual opinions of the legislator, nor even by the resolution of the entire legislature. Legislative drafting is done by the legislative department of government, and it is legislation that controls and regulates the conduct of citizens. Therefore, the job of the draftsman become most important and more important. And what is the job of the draftsman? What he is supposed to keep in his mind. First thing which the draftsman has to consider is what is the object of the proposed legislation? What the government intend to do by passing this legislation? What is the objective which it want to achieve, and whether that objective is within the constitutional framework or the principles laid down in the preamble of the Constitution, or in the directive principle of Constitution, or in other parts. Then, what is provided in the existing law with regards to the same subject? If you have an existing law on the same subject, then what is provided in that? What is lacking in that legislation, which now we want to make, and whether the new legislation need an independent legislation, or by making an amendment in the existing legislation itself, the objective can be achieved. The other point which the draftsman has to keep in mind is whether the proposed legislation will be in conflict with the provision of any of the central or state enactment or provision of the Constitution, and if it is so, how best it can be harmonized. If you can't harmonize, if you can't do it, and it's going to violate the provision of the Constitution, such legislation will be struck down by the courts. And another important aspect which the draftsman has to keep in mind is how any existing law might be affected by the proposed legislation. If any existing law is going to be affected by the proposed legislation, necessary changes also need to be made in that. Take, for example, recently the Parliament passed a Mediation Act of 2023. I hope the participants here may be knowing it. We have a standalone legislation now which recognizes mediation, and even a private mediation is also binding on the party if it is certified by the mediator and is not against the provision of the law under the Mediation Act. It is enforceable. Now, in that Mediation Act, which is standalone, prior to that, provision for settlement of disputes through mediation were made in many other legislation, in the Commercial Courts Act, in Arbitration Act, in MSME Act, in Companies Act, in IBC. All these legislation had provision relating to mediation. Now, once this standalone mediation law was passed, all these enactments, wherever necessary, were also amended by adding a separate schedule to the Mediation Act, so that to bring it in conformity with the new mediation law which was passed by the Parliament. So this becomes a duty of the draftsman to ensure that there is a harmony in the different legislation and there is no conflict in the new legislation and the existing legislation which has been passed. In addition to this, what an Indian legislative draftman has to see, and this is, I think, more important than anything else, he must have a very good knowledge of the subject on which he is going to draft. No doubt, it is for the policymaker, the concerned administrative ministry, to give a broad policy on which the law is to be made. And draftsman's job is only to give a legal shape to the policy of the government, which is being given by the concerned administrative ministry. But that can be done only if he has fully understood the policy of the government, and he fully understands the legal principles, and he must be familiar with the legal principles as expounded by the court from time to time. Unless there is a clarity, there will be pitfalls in the law. And another important point is he must have full and intimate knowledge of the Constitution, particularly fundamental rights and provisions relating to distribution of legislative powers between the center and the state. I said it earlier, he must know that if it is the parliament and the legislation is to be passed by the parliament, whether the parliament is competent to make that legislation, or that subject matter pertain to the state list under list 2. In case it is in list 2 and parliament makes a law, such a law will be struck down by the court. Similarly, if the power is with the parliament and state makes a law, the courts will struck down such a law. So therefore, knowledge of the person drafting, he must know that there is a legislative competency of the legislature to whom the law has been referred for passing. More importantly, knowledge of procedure of the parliament or legislative assembly, administration, courts at work, including societal living condition, is very important. Now take for example, I'm just giving you a wide example because this subject has been again debated, and I came across recently some articles on living will. And I think most of you understand, we can make a will with regard to our property, but with regard to your life, can you make a will? Of course, those who know about this subject, in Aruna Shanbag's case, way back in 1995, the Supreme Court laid down certain principles about living will, and they said about the passive euthanasia and active euthanasia. I'm not going into the detail of it, but debate has again come, a law to be made on it, that as you have a right to life, similarly, a right to life and a dignified life, therefore, the individuals must have right to die and die dignifiedly. If a person has gone in a vegetative state, he cannot be recovered, he is bedridden, and probably he cannot be revived in spite of all the medical attendance given to him. And the doctor certified that probably he cannot live. Therefore, the opportunity should be given to allow that person to die peacefully. Now, whether we should have a law on this aspect, what are the pros and cons of this law? If you make this law, will it be misused? What are the safeguards to be inbuilt for such a law? And whether our society will accept it. What are the positions available in other societies relating to this particular law? How it has been implemented, whether it has achieved the objective for it was made, or it is being misused. I think all these principles will be examined by NGOs, by policymakers, by people who are relevant, who knows this subject. And with this background, once they give a broad policy framework to the draftsman, probably he will be in a position to draft a better law, putting sufficient safeguards to ensure that this kind of legislative provision, which will be passed by the parliament, is not misused. So I think this all, before I go further, I have already told you that how the drafting has been done in the past under certain legislation, where of course the drafting could have been much better, but most of the legislation now which are coming simple language is being used. Take, for example, the Digital Personal Data Protection Act. There was a lot of thought process which has been gone into. Arbitration and Conciliation Act, there was a pre-legislative consultation process. Similarly, in the Mediation Act also, there was a pre-legislative consultation process. People were consulted and the laws were made. And I personally feel that we are moving in that particular direction where laws are being simplified. But again, the draftman has to be very conscious that simplification is not at the cost of clarity and preciseness. I'll stop here for a minute in case any of the participant has any issue or has any question or has any doubt. I'll give an opportunity to clarify it before I proceed further as to what draftsman is supposed to do when he has to make this legislation. Any question, any doubt, any clarification, any of the participant want?
Participants can unmute themselves or you can write your question in the chat box.
Okay, Saurabh, then I think I'll take the questions, little later. Let me complete or finish what more I want to say on the subject. Now, coming to the general principles of drafting of the bill, which is the subject matter, then as I have already said, a draftsman must have a clear idea of what he is required to draft. And that is generally given by the concerned administrative ministry in the policy framework. And having mastered the subject, the draftman should also look at some of the precedents which are available, whether nationally and internationally. But we have to be very conscious when we are looking at the international precedents, whether those international precedents are suitable to the social and economic scenario of our country. Here I'll again stop and give an example. The Arbitration and Conciliation Act of 1996, which was passed by the Parliament, is based on a model UNCITRAL law of the United Nations. But what happened, when we passed this law, we copied as it is the model UNCITRAL law of the United Nations. Unfortunately, when it comes to implementation, we realize that most of the provisions are more relevant to the international commercial arbitration and they are not relevant for domestic arbitration, and probably more thought process should have been gone into it. That led into a lot of litigation, and you must have seen that from 1996 till date, large number of judgments, decisions, orders have come, not only from the high courts, but from the Supreme Courts, even with regard to the appointment of arbitrator by the court, whether it is a judicial order or it is an administrative order, then with regard to filing of appeal under section 34 of the Act or 37 of the Act, what procedure should be followed with regard to the interim relief to be granted to by the parties, whether it should be granted by the arbitrator or by the court. So many issues had arisen. And after such a long time, we could amend that law for the first time only in 2015. So if we are adopting some international precedents, before adopting that, it is the job of the legislative draftman to see whether it is suiting our social and economic scenario or not. I think that becomes a very important point from legislative drafting point of view. And before actually drafting a bill, it is always advisable for a draftman to prepare a rough scheme of the bill. The proposed marginal headings of the clauses will generally give sufficient indication of the subject matter of the clause. I remember long back a draftsman who was, of course, my senior in the Ministry of Law and Justice. There was a proposal to merge the National Airport Authority and International Airport Authority of India. And one bill was to be consolidated into one authority. The two legislations were to be merged into one. What he did after getting input from the policymaker or the Ministry of Civil Aviation, he himself attempted a draft. And that draft he gave to the ministry. Well, this is the basic draft. Now you critically examine it, give your input so that it can be further improved. Similar exercise was done in many other legislation. Sometimes you have a time constraint and you can't devote that much of time. But whenever you do some pre-legislative consultation process or give a draft to the people who are actually involved with the subject matter, probably you can get a better law, better draft of the legislation. This was one such example, and I think the draft which ultimately came was such a good draft that its implementation became much easier. And again, I'm coming back to the language. When the draftsman is drafting a law, he must use simple language. Each clause of the bill should contain one idea only. There should be no multiplicity of ideas in the same clause. If an idea is complicated, it should be expressed in a series of subclauses, and subclause should not normally be more than one sentence. The kind of legislation which I have referred to, Section 80 HHC of the Income Tax Act, or law relating to terrorist act or sedition, which I have mentioned to, or the other unlawful activity act, which I mentioned. I think there are some complicated legislation, and I'll give you another example that once you are making a law, because now we are entering into a territory where, say, the laws which were made 50 years back were very simple, pertaining to civil laws or criminal laws, and probably now, of late, for the last about 2 or 3 decades, the laws are coming more and more technical. You have law relating to artificial intelligence, information technology law, cyber law, IPRs. These are, I think, laws which have become more important because they relate to the commercial world. Stakes are very high. Issues are complicated. We don't have the clarity because even international precedents are not available. Therefore, how to go about it? Should we go for lengthy legislation running into 600 pages? Or should it be an enabling legislation where the legislature enables the technocrats to make the laws or supplement the principal legislation with rules and regulations? I think that's a big issue. As a student of law, I personally feel because of the technicalities which we are going into, the legislature should only make an enabling legislation, enabling the executive to supplement that law with the rules and regulation so that they can be frequently amended to meet the requirement of the society. And this practice has been followed even in the past also. I gave you example of Income Tax Act, which is a complicated law. But at the same time, we have certain simple legislation also. I'll give you 2 examples. One is our Excise Act. The Excise Act was such a simple legislation running only into few sections, and most of the laws were regulated by rules and regulations made by the executive or by the Central Board of Excise and Custom. Similarly, we have Essential Commodities Act, which is a very small legislation, but has been very effectively implemented by the central government and state government. The idea which I'm giving here is, because of the technicalities which are being involved in the law today, and our legislature not being that technically expert, it is better that we leave the details to subordinate legislation, and principal legislation should be only an enabling legislation under which you enable the executive or the statutory bodies to make law. So I am a votary of a person where, without compromising with the essentiality of the principles of legislation, essential legislative function should not be delegated, but rule-making power and regulation making power should be such that laws can be changed frequently to meet the present-day requirement. But that frequent changes should not be, again, a word of caution, at the cost of stability, and it should not lead to uncertainty. Therefore, the draftman should also provide for all kind of contingencies which are likely to arise in future. Now, all these drafts which are prepared, and before I come to this particular point, I just want to highlight for the benefit of my participants here, can anybody guess when this GST law was passed, how many drafts must have been prepared? The first draft started way back in 1991 or 1992. But ultimately, the law was passed only in 2015. In between, is there any wild guess how many drafts would have been prepared for this? I think it can be anybody's guess. But my personal information is there were more than 200 drafts, because every time when the draftsman brings some change on the basis of recommendations made by the policymaker or by some committee or by some group, expert group, fresh draft is prepared, and that fresh draft with the changes which have been brought is again considered. The point which I'm trying to make here is that draftman cannot say that whatever I have written today is final. Quite possible as a draftman, I draft something. I drafted it today. But at night, something comes to my mind. Oh, I have forgotten this particular aspect. Next day morning, I go back, make necessary changes to make it perfect. So ultimately, till the law is passed by the parliament or a bill is introduced in the parliament, the draftman always has a point or a scope to make changes in the legislation to make it as perfect as possible. Let me tell you again that no law is perfect, and probably you can't make a perfect law. But definitely you can make better laws depending on the experience you have acquired and the precedents which are available or the interpretation which is given by the court from time to time. So the point which I'm trying to make here is that once you are making a draft, all these drafts should be preserved. They indicate the working of the mind of the draftman and are useful when any question arises why a particular provision has been put in a particular form in the final draft. I give here an example, the Constituent Assembly debates. The drafting of the Constitution, which has taken almost 3 years, we all of us know that there were debates, and all those debates are now available to us in public domain. And whenever there is a question of interpreting a particular provision of the Constitution, the council argue on both sides. They refer to the Constitution Assembly debates and tell why this particular provision was incorporated. Similarly, here also, when you make a law, and if you are preserving all the drafts, you can always tell when the constitutional validity of a law is challenged in the court. You can always explain to the court that this was the intention of the legislature and this is how the law was drafted. So I think preserving those drafts is very important. And when a draft bill is ready, again, it should not be given a second reading immediately. I give you an example. An accountant, he is a perfect man. He starts calculating. When he is making calculation, he says 3 plus 2 is 5, 5 plus 3 is 8. And he goes on calculating that, and ultimately he does the sum total. But somehow, I mean, it is a human brain, it is a human mind. What he does, unfortunately, because his mind is working elsewhere, he says 2 plus 2 is 4 plus 3 is 8 plus 2 is 10. He has committed one mistake. And if he repeats it, maybe he will be repeating this mistake. But if he cools down and after 10 minutes, he again examines it, maybe he will rectify the mistake which he has earlier made in calculation. So similarly, for a draftman, if he has drafted a legislation, he should leave it and do the second reading again after 1 day or 2 days or whatever is possible. And drafting should not be done only by one person. I tell you the experience, my own experience of law ministry. There is always a team of draftsmen, large number of draftsmen, 3, 4, 5, depending on the legislation. They all sit together and draft a legislation. Take, for example, I mentioned about the GST. Maybe about 10 or 15 people were directly involved in its drafting, and every day they were improving upon it. The criminal law amendment bill, which was introduced in the parliament after Nirbhaya case in 2012, there were 12 draftsmen who were working day and night and working on its improvement. And ultimately, the law was passed, and you know that law is working well. Law is working well, its implementation, there may be issues on that. I'm not going into that particular aspect because that is not the subject matter of discussion. So if a draft bill is revised immediately, the mind of the draftman is likely to be more on the same groove, with the result that he may not notice any mistake. But if he is doing it after some time, he will notice it. If the draft bill is revised after an interval, the draftsman will be able to bring a fresh mind to bear upon the draft and will thus be in a better position to detect a mistake. And whenever possible, as I said earlier, if a bill has been drafted by one draftsman, it should invariably be scrutinized and examined by the another draftsman also. And before finalizing it, the concerned administrative ministry, which is a policy maker, must also be consulted that whether the objective which they want to achieve by that draft has been achieved or not. And when a bill is referred to the select committee of the parliament, the draftman before attending meeting of the select committee should go through all the relevant papers to refresh in mind, to brief the select committee so that he can tell the select committee as to what was the objective which exactly they wanted to achieve by passing that particular legislation. And particular care should be taken in drafting financial statutes because generally financial statutes and the criminal statutes are given strict interpretation by the court. So any ambiguity left in that, the benefit goes to the individual. And at that time, you cannot look at the objective, which is the principle generally followed for social and economic legislations. And also a draftman must have ample time to prepare the bill. I think this is one area which is a matter of concern. Nowadays, we have found many a time, some of the state legislature, they approach the draftman by saying that, okay, this is the bill we want to introduce in the next parliament, in the next session of the assembly, which is 2 days after, and immediately they want a bill to be prepared. If you are preparing a bill hastily, there is a possibility of committing more mistake. There will be no due public consultation, and that may lead to many mistakes and ultimately drafting error also, which need to be avoided. So if I have to sum up all these aspects with regard to the drafting of legislation, I will say plain language should always be preferred to ornamental and generic legal language. It will avoid, reduce, dispute, and facilitate effective communication. It also saves time and money and increase business and profit in commercial transaction. I generally advise, I have been generally advising my draftsmen, which doesn't happen because of scarcity of draftsmen and there being a lot of work. Whenever a constitutional validity of a legislation is challenged, I think it is always better that the person who has drafted the law, he should go and sit in the court and hear to the arguments on both sides as to how they are interpreting that particular legislation and what is the reaction of the court with regard to that particular drafting. I think that will make him a better draftsman and he will be in a position to draft better legislations. Drafting legislation cannot be done only based on the precedents available. Precedents can definitely give you an idea, but that cannot be the final thing. You can't be a perfect draftsman or a good draftsman sitting in the four walls of your room. You have to go out, discuss with the people, take public opinion, and only then come out with a good draft. So a good draftsman is one who has clarity of basic constitutional provision, understand the subject well, and has good command over the language in which law is to be drafted. He has the capacity to draft the laws in a plain and simple language that can be understood by the common man and without compromising with the basic drafting principle. Retrospective evaluation may check efficacy, effectiveness, and efficiency of the law on regular basis. I think this should be a regular exercise which is to be done. This check may finally lead to an amendment and the law returns to the parliament after a full circle. Drafting the legislation must be done as precisely and carefully as possible, making use of all scientific instruments of legalistics. And I would like to conclude by saying neither the politician, nor the drafter, nor finally the depute must, however, forget that the founding fathers of the Constitution, in drafting the text, said the law of the land must always be by the people, of the people, and for the people. If the people for whom you are making this law, they don't understand the law, and if you are making a law which only is the domain of the experts on the subject, that is the advocates, chartered accountants, or company secretaries, then probably the objective of social goal which we want to achieve by making these legislation for the common man cannot be achieved. So simplicity, but that simplicity should not be at the cost of clarity, and the draftman must ensure that ultimate objective of serving the common good, common cause within the framework of the Constitution is achieved by legislation. And I think our government is now working in that direction, consolidating the law, repealing the obsolete laws, and simplifying the complicated laws. We are already moving in that direction. Only thing is we have to see how long more it will take when we can say that here is a legislation which everybody understands. If it is meant for a common man, he understands it. With those words, I conclude my presentation, and now the floor is open for questions, if any, from the participants. I hope I have not taken more than the allotted time. Thank you very much.
Thank you, sir. Now we open the floor for question and answer. In case anyone have any question, they can directly ask to the sir, or you can write in the chat box. So there is one question that if draftman can tell administrative ministry that policy broadly is not complete or suit socio-eco ethos of India and challenge and change the policy.
Yes, that right is always available to him. That is the observation that will be made by the draftsman. As I told you, draftsman come at the second place. Before that, it is the legal advisor who first scrutinizes that policy paper or the draft document, whether it is as per the provision of the Constitution, it is not violating any of the fundamental right, and the legislature has the competency to make that particular law. Once the legal advisor gives that opinion, only then it goes to the draftman for drafting. The draftman's job is to carry out the policy, but his job is not to question the policy. But in case he finds that it can be improved, he can give a suggestion to the administrative ministry to reconsider it. But after reconsideration, in case he is given a mandate, draftsman's job is to draft the law, to carry out the policy of the government, and not to question the policy.
Yes, Rathod ji.
Yes. Sir, thank you very much for this enlightening session. Sir, I have two questions. Initially, as you have mentioned that these entries doesn't have a power regarding law making, and you have added that this power reside and this and you have also added that this power reside in some other provisions of the Constitution. Sir, can you tell us which are the relevant and important constitutional provisions which
Yeah, I think during the course of my discussion, I have talked about the distribution of legislative power, which is in Article 245 to 255. And probably the reference to these lists is also there in this Article 246, Clause 1, 2, and 3, because Clause 1 says Union can make laws on the subject which are listed here, because that distribution become necessary because we are a federal government. In the federal, there is distribution of the legislative power between the center and the state. That and therefore this list is only illustrative within that. But as I said, the Supreme Court itself has said that you have to give a liberal interpretation to this, so that the legislature's hands are not tightened, not to make a law on a particular subject saying that this is not covered. And therefore, and residuary power, as I said, is already available with in list 1. Now take for example, even with regard to a state subject also, the central government can make law, and that power, where it is available under in the Constitution. If I correctly remember, Article 253 of the Constitution provides that if you have to give effect to an international treaty where India is a party, in that case, the central government, even if the subject fall within the state domain, Parliament can make a law on that subject. Even with regard to state subject, if 2 or more states agree that center should make a law on that, the state legislature can pass a legislation empowering the center to make law on that subject, and on those in those particular states, the central law will prevail. So that power is found in the relevant provision of the Constitution, and they are not restricted only to the list.
All right. Thank you, sir. Sir, in addition to that, sir, whether is there any distinctions between the process of lawmaking regarding Parent Act and subordinate acts?
Well, I won't call subordinate act, it is a subordinate legislation. The
Yes, sir.
parent
Sorry, sir.
legislation, principal legislation, we call it principal legislation. You see, principal legislation is generally to be passed by the legislature only. Whether it is the parliament or the state legislature, whosoever is competent, we call it principal legislation. As I said, we are going into the technical era. There are many laws which are technical in nature, and even if they are not technical in nature, Parliament doesn't have that much time to provide for each and every detail in the principal legislation. So what they do, without compromising with the essential principles of legislation, they make a broad law, and while making that law, they give power to the executive to make rules to carry out the purposes of that act. Once you give that power to the executive to make rules, that rule become a subordinate legislation. In addition to that, nowadays we are creating many regulatory bodies. Take for example, SEBI, IRDA, IBBI, they are all regulatory bodies. These bodies are also given power to make regulations. So in the principal legislation, whatever you are providing, rules further supplement the provision of the principal legislation. And the regulations further supplement the provision of the act, and the rules, they further supplement it, they are more procedural in nature. But they must fall within the policy made under the act. So principal, as I said, essential legislative function cannot be delegated, that remain with the legislature. Rules can be made within the framework of the legislation, and regulations can be further made within the framework of the principal legislation and the rules made by the central government or the state government, as the case may be.
Thank you very much, sir.
Sir, there is one question in the chat box, that how we can start practicing legislative drafting.
I think that's a very good question. Nowadays, the procedure of internship is available in all the ministries of the Government of India. Similarly, all the state government law department also, they give internship for that. And the Ministry of Law and Justice is also running an institute which is known as Institute for Legislative Drafting. They also conduct some kind of orientation program, but that is meant only for serving officers. It's not. But intern can always go and approach the ministry, and they will be attached to the concerned officers who will be guiding them as to how the drafting is done. And I think some of the educational institutions have also introduced it as a subject. Now, some of the institute where I am associated, I go as an advisor. I also do the same thing. And I think they can enroll themselves when they're conducting the courses in legislative drafting now, like the one you have done it. Similarly, they are also having some 40-hour course or 1 week course where they are doing some practical training for drafting. They can approach those universities and associate themselves with the School of Law of that university. I tell you, I mean, we don't have many good draftsmen available in our country. There is a dearth of draftsmen. This is one area where the student of law can explore the possibility. This is a very, very specialized area. Well, initially, some people may say that it's a very dull subject because you have to work day in, day out. But I tell you, they are too much in demand. And so far as remuneration is concerned, now because I am also in this field, I am also doing consultancy, it's very remunerative also. You are muted, Hiranshi.
Yeah. Vaishnavi.
Good evening, sir. Thank you so much for such an insightful session on legislative drafting. My question to you is,
Vaishnavi, can you be a little loud?
is there any procedure through which the draftsmen are selected for drafting a bill? If yes, do they go through some comprehensive training?
No, unfortunately, I think I started my discussion with this, and I think I'll again repeat it, and probably that will answer your question. This is the opening sentences of an article written by Justice Brijesh Kumar, where he has said, and I entirely endorse this. This is the problem in not only in our country, in other countries also. Legislative drafting in itself is a subject of serious study, but unfortunately, it appears that in India, required attention commensurating to the importance of the subject has not yet been given to it. By and large, drafting of statute is generally in the hands of those who do not have specialized training and experience in drafting, so to say, in the hands of the law knowing layman in drafting. They are law knowing, but they are laymen in drafting. And I tell you, normal practice is all the draftmen, they learn this kind of legislative drafting while working on desk. And it is the seniors who have already worked in the department for say 10 years, 15 years. They guide them, they support them, and they tell them how to do it. Initially, the draftsman is given training in drafting subordinate legislation, rules and regulations and orders. And only when he has acquired some experience, only then he is involved in drafting of principal legislation. So this is an ongoing process. Some improvements have been made, and I think some training courses at international platform and national platforms have already begun, and people are taking advantage of that. And not, but if I have to say it in one sentence, most of the time the draftman learns the drafting while he is on desk.
Thank you so much, sir.
Thank you, sir. Now I would like to invite Dr. Kalpesh Gupta to give vote of thanks.
Thank you very much. I hope I'm audible. Sorry, I had joined from mobile.
Yeah,
and
please. Yes, Dr. Kalpesh, you are very much audible.
So thank you very much, Malhotra sir, for your. I would say you rightly set the stage for upcoming topics, like because your vast experience I can see. And then related to such topic, there are a couple of institutions like in KIT Law School. They're offering this course in legislative drafting as a part of law curriculum. This is a great. I invited, like, there is a faculty development program, so invited faculty that she's a dean now. So there's a program on how to teach a particular subject. So I requested Madam, so Kevalia, Madam Professor Kevalia, so how to teach legislative drafting paper in Indian law school. So that was a topic. So first time I got to know, I don't know any other law school they are teaching, because there's an elective course. Anybody would like to take up those kind of courses. And sir, one of important thing, like association, one of the participant asked, like LAM fellowship, legislative assistance to member of parliament. So that's again great. PRS legislative they are doing. So that's a good opportunity for all the participants. They can be a part of with MP or MLA also. Maybe I have not heard anything like MLA is offering anything, but they can reach out to MLA and then assist them making legislation or rule of regulations. So thank you very much, sir. On behalf of organizing committee, we are grateful for your wonderful time and a great insight. I would say that's not possible from any layman or maybe less experience of in this particular field. So thank you very much. I look forward to see you in future episodes.
Thank you very much.
Thank you.
Thank you.
Thank you, everyone. Have a great evening ahead.
Excuse me, I'm having one doubt. If you may allow just me to ask.
By all means, please, I'm still here.
Exactly, sir. Even I have a doubt.
Welcome, sir.
Good evening, sir. My question is that, sir, what could be the call to action for today? I mean, just how we can start it from our home legislative drafting.
You see, what I will suggest is, most of the time, as I said, there is a process of pre-legislative consultation process, and many of the bills, of course, all bills should be put in public domain before they are finally taken to the cabinet. But I think in all bills, this practice is not being followed. But in most of the cases, the government has started following this practice. Take, for example, the income tax bill, new income tax bill is now in public domain. So I think this is one area where those who are interested, they can look into the bill and they can make their suggestion to the parliamentary committee, to the Ministry of Finance and other, that these are the changes which you are suggesting in the bill. You find these are the deficiencies, give your reason for that. And I think that is the best way to start with it. And I have always been suggesting in other educational institutions also where I am associated, I generally tell the faculty, and I generally tell the senior students who are interested in legislative drafting, always look for this kind of consultation papers which are circulated, whether they are with regard to rules, whether they are with regard to the regulations to be framed or the principal legislation. Whenever such thing come in public domain, go through it, read it, go and appear before the parliamentary committee and make your submissions. I distinctly remember long back when I was working as a secretary and I was assisting a committee for a particular bill. Two students from law college in Mumbai came and made their presentation before the committee with regard to a particular bill. And I was really surprised the kind of input which they were given. Even a advocate of long standing probably would have hesitated in giving that kind of suggestions, because the innovative ideas which the young mind can bring on the table is generally cannot be brought by a man like me who is moving on a beaten track, who know a particular system. I can't think out of the box, but the new young generation can think out of the box by using technology, by the innovative ideas or the new things which they have seen in their life using the technology. So I think you can start with this particular aspect. Whenever a bill or an act or some consultation paper is put in public domain, start giving your idea and start giving your suggestions as to how this can be modified or this can be amended. That can be the starting point.
Okay, sir. So the public domain here means the government websites and the gazette, right?
Yes, invariably, I think you get public notices also, and even the Parliamentary Standing Committee also, when the bills are referred to them, they issue a public notice calling for the public comments. And even before that also, as I told you, way back in 2014, the Government of India started a pre-legislative consultation process under which it is obligatory, mandatory for every ministry and department to put all these rules and regulations in public domain and call for the public comments. When the public comments are called, you can always make suggestions for the kind of modifications which you would like to be made. The recent example, as I told you, is I said that I will mention at the end, which I forgot. The finance bill contain a validation clause, which is amending the Central Civil Service Pension rules, which deal with pension to be given to the retired government servants. For the last 2-3 days, a lot of debate is going on this, because this validation, the methodology which has been adopted by amending, bringing a validation provision in the bill itself has been questioned, because it's a novel novel idea which has been introduced in this bill. Normally, validation laws are passed separately, giving the reasons as to why this validation bill is being passed, and then the provision are made in the law. But this new methodology has been adopted, which has, if you read even today's paper, there are some articles in that also, why this pension, right of pension, which is a fundamental right recognized by the Supreme Court, is being taken away by this validating legislation in the finance bill of 2025. This is a separate topic of discussion. I won't discuss it. But what I'm saying is new ideas are coming, and you have an opportunity to make presentation of this kind of suggestions when they are sought from the public.
Okay, sir. Thank you very much. And sir, any other books which you would like to recommend on this particular topic of legislative drafting, the subject?
I think there are not many books available of the Indian authors, but yes, there was some books which I can refer to. Is of course I'll share it later on, but I can send it to Hiranshi and she can share it with the participants on a later date. One is published by the Indian Law Institute. It is again a very old book, but so far as the drafting principle are concerned, there is not much change in the drafting principle. So even if it is an old book, the principles laid down therein are valid even for legislation today also. Then another name which I'm missing, he was again an officer of the Ministry of Law and Justice. He also came out with a book. But unfortunately, these publications are not easily available in the market. But definitely I'll share the title of this book with the name of the author, with the organizers in a day or two. You will get it later on. Thank you.
Thank you, sir.
So I have a doubt as well.
Yes, please.
So like you started the conversation about how judiciary is such an important stakeholder of the process of bill drafting.
Hmm.
So, sir, my question is that if ultimately it is the judiciary who has to interpret the law, who has to interpret these very bills, why isn't it involved in the drafting process itself? Because that way, like, wouldn't it get easier for the judiciary to interpret it?
But Sahil, please remember, legislation, passing a legislation is in the domain of the legislature. We have a constitutional scheme. Under that constitutional scheme, judiciary interprets the law, legislature make the law. But while making the law, what I'm saying, the process which should be followed, probably your suggestion is, can there be a consultation with the judiciary in that? The moment you start consultation with the judiciary at the time of law making, probably you are binding the judiciary. Well, you were consulted, therefore now you cannot go into the constitutional validity of it. Even if certain valid points to challenge its constitutional validity are available or are brought before it while arguing the matter or while arguing its constitutional validity. So each organ of the government has to work within its domain at the relevant time. We don't want to take away the power of the parliament to make the legislation or restrict the power of the parliament to make a legislation. Take, for example, I give you just one example. Of course, it again involved legislation with regard to appointment of the chief vigilance election commissioner or the chief vigilance commissioner or director CBI. The involvement of the CGI has been there. The committees have been constituted where CGI is involved. Now there is a debate going on. If CGI himself is involved in appointment on these posts, tomorrow, in case the validity of these appointments or legality of these appointments is challenged, probably there will be a restriction that when the Chief Justice himself was involved in the appointment, how can there be an illegality to that? So I think each organ has been assigned a job. Let the organ do its job. Yes, the legislature, when it sends it to the public domain, the legal fraternity gets an opportunity to make its presentation. But judiciary as such should not be involved in the law making process. It is involved in the law interpretation process, not in the law making process.
Thank you so much, sir. With this, we are conclude our today's session or first session of 10 days capacity building program. Thank you, everyone. Once again, thank you so much, sir.
Well, I must thank Sambhav Initiative as well as Pro Bono India for giving me this opportunity to interact with the participants. And I'm very happy that participants have, with the interest, I think they have listened to or tolerated to whatever I have said. And there were questions also, and very relevant questions they have asked. I'm happy to, and I hope that I could satisfactorily answer those questions. Thank you very much. Thank you.